I think I'm going to make a start. Apologies to any more late arrivals. The webinar is being recorded, so if you do miss any of it for whatever reason, you should be able to find a link to it on our website in a couple of days' time. So good morning again. For those who don't know me, I am Kriti Upadhyay. I am a barrister in the Guildhall Chambers Personal Injury Clinical Negligence team. I have a practice covering a number of areas of, broadly speaking, healthcare related issues, including primarily clinical negligence and personal injury, but also I deal with health and welfare matters in the Court of Protection and healthcare professional discipline, so representing medical professionals in front of regulators and so on. Thank you for joining us today for this clinical negligence update. But the plan is a bit of a journey back through some of the key clinical negligence decisions that have taken place so far in 2022. We're going to start with the most recent and then work our way backwards. I'm afraid it's not, for the most part, been a year where there have been any seismic changes in the law. There haven't been any hugely major cases on the scale of something like Montgomery, for example. And probably the biggest development of all is the case I'll come to last, which is the decision of the Court of Appeal dealing with secondary victims and psychiatric injury cases and when they can or can't recover. And that, as some of you may know already, is a case that could deal with, that could be dealt with all in a talk by itself. It's customary in these sorts of things to have a bit of a Q&A at the end of the talk, but I think 2 years of doing webinars have taught me that when you're all online, these are mostly a bit of a recipe for awkwardness. So instead, I won't be taking live questions today. I won't be asking anyone to try and unmute themselves and talk, don't worry. If you do have any questions about any of these cases or any other cases this year that haven't made it to my list, then please do feel free to email me either directly or via my clerks. And my contact details are at the end of this PowerPoint for anyone who doesn't have them already. So with the introductory bits over and done with, and morning again for those who've joined us in the last couple of minutes, I'm going to move on to the actual cases. I'm going to start with Court of Appeal decision from May 2022. It's a costs decision because, of course, I know everyone loves some costs first thing on Thursday morning. So cost cases, of course, will either bore you to tears or are of the utmost importance, depending on how much time you spend dealing with those issues yourself. But there is a bit of important and succinct guidance from this decision. That's why I have included it. So the background to this case is proceedings arose following a clinical negligence claim in which the claimant was represented by Erwin Mitchell. The case had been running for some time, and at the end of it, the claimant solicitors produced two sets of bills. One was a paper bill in respect of the period up to April 2019, and then an electronic bill in respect of the rest of the claim. The defendant complained about various aspects of the claimant's compliance or otherwise with the procedural requirements set out in the CPR. So it was initially dealt with by the Senior Courts Costs Office and then appealed up to the High Court and then on up again to the Court of Appeal. So one of the core issues was whether a bill had to give the name of the person who had done the piece of work in question. The Court of Appeal identified a distinction here between paper bills and electronic bills. So there's some helpful guidance in the decision, which is just worth bookmarking for future reference. So looking first at paper bills, the court held that the party preparing the bill did not have to specifically name fee earners. So in practice, the court said fee earners are very commonly named even in paper bills, and it is desirable that they should be. And doing so could be of help to both the paying party and the court, and it's hard to think of a good reason for withholding the identity of fee earners. But on balance, I agree that the paper bill does not strictly have to include the fee earners' names. But in respect to paper bills, the court went on to confirm that a paper bill must state any professional qualification of a fee earner, and unless the SECO grade is given, the years of post-qualification experience. So you don't have to name the fee earner specifically, but you must state their professional qualifications and years of experience. But looking at electronic bills, the court's emphasis was that the system of electronic billing had been intended to increase transparency. So they adopted the comment made by Mrs. Justice Steyn in the High Court below in this case, that without a breakdown of work undertaken by individual fee earners, it's impossible to know whether, for example, two different fee earners within the same status category each spent an hour working on the letter on consecutive days, or whether only one fee earner spent 2 hours across 2 days working on it. This kind of information is capable of revealing that work has been duplicated in whole or in part. It's also impossible to detect, for example, if a claim has been made that an individual fee earner undertook, say, 10 hours of work on disclosure on a day when a claim has also been made for the same fee earner's attendance at a one-day hearing, giving rise to questions about the accuracy of the claim. Such anomalies are hidden if the work is claimed by reference to categories of fee earner. In addition, the provision of the names of fee earners enables the paying party to check the expertise and experience of individual fee earners when considering whether the rate claimed is reasonable. So the Court of Appeal then went on to rule that any electronic bill, whether in precedent S spreadsheet format or any other spreadsheet format, must include the name, the SCCO grade, and insofar as it adds anything to the grade, the status of each fee earner, except possibly insofar as the receiving party solicitors may have outsourced work to an agency. And as to the effect of this receiving party's breaches, in this case, the court was quick to note that it is very far from the case that a bill of costs which fails fully to comply with the rules should invariably be struck out, let alone treated as a nullity. Typically, a defect will at most warrant a lesser sanction, which will no doubt come as a relief to those of you with bills of costs as receiving parties. And in this case, the Court of Appeal then upheld Mrs. Justice Steyn's decision to strike out the existing bill of costs, but order the claimant to serve a replacement which complied with the CPR. So not as draconian as it perhaps first appears. I'll move on then to the next case, which is Richins and Birmingham Women's and Children's NHS Foundation Trust. This is a High Court decision in Birmingham before Her Honour Judge Kelly. It's a very sad case. The claimant's son was stillborn. She suffered nervous shock and as a consequence developed PTSD and obsessive compulsive disorder. It was her first pregnancy. She was due to give birth in September 2008. She attended an appointment in July 2008 at the defendant hospital's day assessment unit, and because aspects of her presentation were worrying, she was then admitted as an inpatient in hospital, and sadly her condition deteriorated over the evening of the 6th of July, so 2 days after she attended hospital, and in the morning of the 7th of July she suffered a massive placental abruption, and the intrauterine death of her baby was recorded a short time later. So her case on breach of duty was that she had suffered a range of serious symptoms over the course of the 6th of July. She remained very unwell overnight and into the following day, and that the midwifery team were negligent in failing to respond adequately to what the claimant said was the obvious deterioration in her condition. And on causation, her argument was that but for the negligence of the midwives, she would have been referred for obstetric review. She would have then been transferred to the delivery suite on the evening before she lost her baby. Once there, she would have been diagnosed with preeclampsia, and her son would have been delivered alive prior to the placental abruption at 6:45 a.m, in which case her psychiatric injury would have been avoided. The defendant, on the other hand, as you can probably anticipate, did not accept the claimant's factual account of her deterioration, but it did accept that if her account was accepted, then there would be a breach of duty. The defendant also denied causation and argued that even if the claimant's account was accepted and a breach of duty was established, her baby would sadly have been stillborn in any event. So in cross-examination, one of the midwives for the defendant accepted that she should have taken a urine test to rule out preeclampsia. And she said she thought she had taken such a test, but she couldn't be completely sure. And in any event, the test results hadn't been chased up. And in the joint statement, the obstetric experts disagreed over whether, if a urine sample had been taken, it would have shown large amounts of protein in the claimant's urine, which would have indicated a problem with her kidneys. So the poor judge was left with the unenviable task of trying to decide what had happened some 14 years earlier on the basis of imperfect witness testimony, potentially missing records, and everyone accepted that the clinical records were not brilliant in this particular case. So the judge, and it's a really interesting and helpful decision to read if you do get the chance, because the judge started by rehearsing the Guestman approach. This is the Guestman and Credit Suisse 2013 Court of Appeal decision, which confirmed what I'll refer to as the Guestman principle. I've set it out there on the slide for you, that the court must avoid the error of assuming that the stronger and more vivid feelings and or confidence of recollection make it more likely that a recollection is accurate, and the broader suggestion that factual findings be based on inferences drawn from the documentary evidence and known or probable facts. And so what the judge did was consider this concept of claimant benevolence. So essentially, whether any issues or whether any gaps in the evidence should be resolved in a way that is effectively benevolent to the claimant. I want to say a little bit more about the Guestman approach. It arose in the PI context first in a noise-induced hearing loss case in 2010. The case was called Keefe and the Isle of Man Steam Packet Company. And in that case, the defendant had failed or allegedly failed to measure noise levels, but asserted that the noise levels would not have been at an excessive level in any event. And Lord Justice Longmore, in his decision in that case, held that if it is a defendant's duty to measure noise levels in places where his employees work and he does not do so, it hardly lies in his mouth to assert that the noise levels were not, in fact, excessive. In such circumstances, the court should judge a claimant's evidence benevolently and the defendant's evidence critically. So similarly, a defendant who has, in breach of duty, made it difficult or impossible for a claimant to adduce relevant evidence must run the risk of adverse factual findings. To my mind, this is such a case. So this was a sort of argument that the claimant in the case of Richins was then relying upon to try and help the court fill the gaps that were left in the evidence. But in this case, the judge noted that the claimant urges the court to apply a benevolent approach to the evidence that the claimant relies upon, and the claimant submits that where it can be demonstrated that there has been a breach of duty, this approach should extend to both factual findings relevant to the breach of duty and to the reconstruction of the hypothetical for causation purposes. And the claimant invites the court to adopt a benevolent approach to the determination of the timing of any positive proteinuria results, the timing of any transfer to the delivery suite, and the timing and outcome of any deterioration on the delivery suite. And the rationale for the claimant's submission is that it is the defendant's breach of duty that has deprived the claimant of evidence that she would otherwise have had to prove her factual case and causation. The defendant, unsurprisingly, argued the contrary, saying that in this particular case there was no role for the principle of claimant benevolence. The defendant submitted, crucially, that the court could simply rely on the expert obstetric evidence without resorting to the need to draw various inferences. So the judge started by making findings of fact that were largely supportive of the claimant's account, and she found that there had been breaches of duty, which included a failure to make an obstetric referral and a failure to take the urine test. And the judge concluded that there had been a failure to transfer the claimant to the delivery suite at around 3 a.m. and that the principle of claimant benevolence did have a role to play in this particular case. But the experts were then divided on when the proteinuria would have been present and therefore on when a transfer to the delivery suite would have been mandated rather than desirable. And the judge indicated that she was willing to take claimant benevolence into account, but then emphasised that that principle does not reverse the burden of proof. And on the balance of probabilities, she preferred the evidence of the defendant's obstetrician, which was that when the urine test should have been done, proteinuria would probably not yet have been present. So taking all of the various breaches of duty and the corresponding issues of causation into account, the judge concluded that it was reasonable for the claimant to have remained on the antenatal ward until the early hours of the morning, but that at around 3 a.m. she should have been transferred to the delivery suite. And she was clear that she was taking claimant benevolence into account in reaching that conclusion. But then that still left the crucial issue of causation to be decided, and particularly whether, if that 3 a.m. transfer had happened, the claimant's baby would have been safely delivered before her placental abruption took place at 6:45 a.m. And here again, the claimant was unfortunately faced with a number of uncertainties about how she would have presented, what various tests would have revealed, if that transfer had occurred, information that she said was lost to her because of the defendant's negligence. But at this point, unfortunately for the claimant, she also faced an insurmountable problem. Her own obstetric expert in evidence would go no further than saying that with the 3 a.m. transfer, the baby might have been saved. And the claimant tried again to rely on claimant benevolence, but the trial judge was very clear that she was not willing to exercise it to patch holes in the claimant's case. Unfortunately, I've set out the crucial passage there, that the hard medical evidence does not demonstrate that it was probable as opposed to possible that the claimant's baby would have been safely delivered before 6:45 a.m. And it is one thing to apply a benevolent approach to the existence of signs and symptoms, but another to use it to construct the planks of causation when not supported by the expert evidence. So essentially, I think it's a warning that you can only go so far when trying to rely on the principle of claimant benevolence and when trying to get a judge to draw inferences as to fact when you have, for example, missing records or gaps in the evidence due to the passage of time and so on. But I would say that by clinical negligence standards, if you do want a really good insight into quite how unpredictable evidence and so on can become when you actually get into court on a clin neg claim, and how a whole case can turn on details and oral statements in court that you weren't necessarily expecting, then I think this is a very good and very interesting judgment to read. Moving on then to Hughes and Rattan. I am going to deal with this case quite swiftly because those of you who were at our seminars at the MShed in March this year have already heard me talk about this case at some length. So this is, however, it is a crucial case. It's a very helpful decision that came out beginning of this year. It's a Court of Appeal decision, and I should say potentially there is an appeal being pursued to the Supreme Court, but we don't know at the moment any more information about it. But the facts are that the claimant, Iris Hughes, had some dental treatment on a number of occasions at a dental practice run by the defendant, Dr. Rattan. She was seen at the practice by 6 different dentists, and she said that 4 of them were negligent. She was not, in fact, at any point in time seen by Dr. Rattan himself, or certainly not at any of the negligent appointments. Dr. Rattan was the owner and the sole principal dentist at the practice, and in this case, and the appeal was a preliminary hearing to determine whether Dr. Rattan might be liable for the negligence of his associate dentists, either because of a non-delegable duty of care to Miss Hughes, or by virtue of vicarious liability. At the first instance, the court found in the claimant's favour on both of those issues, and the defendant appealed. The three out of 4 dentists that the claimant said were allegedly negligent were self-employed associate dentists, and their services were retained under standard British Dental Association contracts. And those there was a schedule of agreed facts between the parties, which basically set out that the NHS dental care was provided at the defendant's practice pursuant to a contract between the Primary Care Trust and the defendant, under which the defendant was contracted to provide dental services to patients at the practice. The GDS contract provided for an annual quantity of courses of dental treatment, and after variation, time spent on dental treatment to be provided to patients at the practice, and it allowed the defendant as contractor to subcontract his obligations arising under the contract, alternatively to employ or engage other dentists to carry out the dental treatment. So everyone agreed that contractually the obligations were those of Dr. Rattan. But he was permitted to subcontract those obligations out to others or to engage other dentists, which in this case he did. He engaged his associate dentists. But the associate dentists who provided this allegedly negligent treatment to the claimant, the court was told that each personally held professional indemnity cover for negligence claims. Each was responsible for the standard of their own work, was responsible for their own tax and national insurance contributions, didn't receive sick pay or pensions from the defendant, had complete clinical control over the dental treatment provided to the claimant at each of their consultations. They could work for other owners or businesses if they wanted, and were responsible for their own clinical audits of their patients. So the Court of Appeal considered the applicable principles, both under non-delegable duties of care and vicarious liability. And as far as the first part of the judgment is concerned, this relates to the question of whether the defendant owed a non-delegable duty of care to the claimant, and the court found that he did. And the way they got to this is the interesting bit of the decision, because they considered the factors from the Woodland case. Again, this is a case that you will all be familiar with. This is the 2014 House of Lords decision in relation to a child who sadly sustained injury during swimming lessons, which had been subcontracted out by a local authority to a third party. And Lord Sumption in that case set out 5 factors, or a 5-part test, which he said had to be satisfied before the court would apply a non-delegable duty of care. And in this particular case, it was the first 3 factors that the Court of Appeal held were engaged. So I'm just going to go through those very briefly. The first of those, the claimant is a patient or child, or for some other reason is especially vulnerable or dependent on the protection of the defendant against the risk of injury. Other examples are likely to be prisoners and residents in care homes. So in relation to that part of the test, the Court of Appeal accepted that it was enough that Miss Hughes was a patient under the care of the defendant. She didn't need to satisfy the court that she fell under any particular category of protected patient or particularly vulnerable patient. It was enough that she was a patient as an adult. The second part of the test is that there is an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself, which places the claimant in the actual custody, charge or care of the defendant, and from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct which will foreseeably damage the claimant. And it is characteristic of such relationships that they involve an element of control over the claimant, which varies in intensity from one situation to another, but is clearly very substantial in the case of school children. And the third factor, and I'm going to take both of those together, so the claimant has no control over how the defendant chooses to perform those obligations, i.e. whether personally or through employees or third parties. So for these 2 factors, the Court of Appeal was persuaded by a number of points, including that the only contract that existed between Ms. Hughes was with Dr. Ratan as the person who was contracted and obliged to provide her treatment. How he chose to do so, whether doing it himself or by subcontracting out to other associate dentists, was entirely a matter for him. And the claimant could have expressed a preference as to who would provide her dental treatment, but she had no right to insist on any particular dentist treating her. So for all of those reasons, the court found without any hesitation, they found that the defendant owed her a non-delegable duty of care. But they did also go on to consider the question of vicarious liability, because it was the second prong of the defendant's appeal, and they confirmed that the correct test to apply was from the case of Barclays, which is a recent decision which you'll all be familiar with. I don't have time to go into that in any detail today, but I have previously done a webinar on the Barclays decision when it came out back in 2020. You should be able to find the full slides for that webinar on our website. In summary, however, the court considered a number of factual points in this particular case. So they considered the nature of the relationship between the associate dentists and Dr. Ratan, and concluded that those factors fell on the side of there not being a relationship of vicarious liability, or there not being a claim under vicarious liability on the part of Dr. Ratan to the claimant. So those factors included that the associate dentists were free to work at the practice for as many or as few hours as they wished. They were free to work for other practice owners and businesses, and some in fact did so, that the defendant had no right to control and did not control the clinical judgments that they made or the way in which they carried out the treatment. They chose which laboratories to use and shared the costs of disbursements in those. They were responsible for their own tax and national insurance payments. And although the defendant took most of the financial risk by virtue of running the premises and paying ancillary staff, they also shared the risk of bad debts. They carried their own professional indemnity insurance, and so on. I would recommend, if you haven't already, giving this judgment a read, because what the Court of Appeal does really well is just set out in summary the legal principles and case law relevant to both non-delegable duties of care and vicarious liability. I think it's a case with broader applicability because a number of dental practices, again, adopt the same standard contracts as were used here, but also the same sorts of principles might well apply in cases involving GPs and GP surgeries with issues of employed or locum GPs and so on. So moving swiftly on, a brief pause, a brief break from case law to remind you that the standard directions for clinical negligence cases, both in the High Court and County Court, have been updated earlier this year. You can find the new templates on the link I've set out on that slide. What's really helpful in terms of what's been put on the website is that they don't just have a copy of the new standard directions order itself, but they've also got annotated versions with some commentary next to each proposed direction. So you do get a better idea if there's any doubt about any particular direction as to what the intention is in terms of what the court might achieve. The thing that stood out to me from reviewing those was the particular emphasis in one of the directions on reducing door of the court settlements, which the annotations say are wasteful of costs, resources and judicial time. So the standard direction will now say that at all stages the parties must consider settling this litigation by any means of ADR, including roundtable conferences, early neutral evaluation, mediation and arbitration, and any party not engaging in any such means proposed by another is to serve a witness statement giving reasons within 21 days of the receipt of that proposal. And that witness statement must not be shown to the trial judge until questions of costs arise. So I think that the helpful thing to remember from this is that if you have another party in a clinical claim who is refusing to engage in proposals for any form of ADR, they do now have the obligation, or I would ask the court to endorse this particular standard direction to remind them that they have to explain their refusal to do so. And again, the annotation to this particular direction also points out that the 21 days provision can be altered by the judge at his or her discretion, and the words "and not less than 28 days before trial" can always be added after the word proposal by the managing judge if appropriate, but this is not necessary for every order. And they can also be added, for example, that such means of alternative dispute resolution adopted shall be concluded not less than 35 days before trial. So there is an emphasis in the amended directions, not just on forcing parties to think constructively and engage in ADR, but actually to try and get those discussions concluded in good time. So if you are concerned that the other side in one of your cases is not going to engage in ADR, or that things might be left too close to the trial date, then I think I would urge you at an early stage to try and adopt in your standard directions, or ask the court to adopt exactly those additions that, for example, such means of ADR shall be concluded no less than X number of days before trial. 35 days seems like a good figure as suggested in the annotations. Okay, moving on then to the case of Trailer. This is again another 2022 High Court decision. It's another very sad case in which a deeply troubled psychiatric patient, relatively recently released into the community by the defendant trust, stabbed his daughter several times and was shot by the police as a result. So the claimant had been diagnosed with paranoid schizophrenia and morbid jealousy. he had a history of violence, particularly towards his wife, and he was on antipsychotic medication, which had been started by depot injection, and he was then discharged on a community treatment order. In the early hours of the 9th of February 2015, he suffered a psychotic episode and stabbed his daughter several times, causing her significant physical and psychiatric injuries, and he was then shot by police officers 3 times. He suffered a cardiac arrest and a hypoxic brain injury, as a result of which he was seriously injured, requiring 24-hour nursing care. He was prosecuted for attempted murder, but the jury found him not guilty by reason of insanity. So what was noted in this particular case was that there had been a risk assessment carried out some months before his discharge from hospital, and that risk assessment included that due to Mr. Traylor's morbid jealousy and his behaviours, Mrs. Traylor was at risk from stalking, threats, repeated accusations, agitation, reported threats to life, reported hostage taking, noted that he'd assaulted a member of his care team, and this seems to be in the context of a deterioration in his mental health. Therefore, when he is unwell, the risk to people in his general vicinity is increased, and Mrs. Traylor and her children are at a risk of psychological difficulties as a consequence of her husband or their father's behaviour. The risk assessment noted that he had used both a knife and a gun in a threatening manner. There was a risk of death for his wife, and whilst detained in hospital, the risk was low, but once in the community, the risk to Mrs. Traylor is high should her husband begin to suffer from mental health difficulties. And there are a number of references in the evidence to Mr. Traylor's unwillingness to take his antipsychotic medication voluntarily. So he was discharged in 2013 from hospital, but subject to a community treatment order, and he was keen in the following year to reduce his medication, but continued to receive depot injections. In June 2014, he saw a Dr. Pisaka for the first time, and he agreed that he would have one more depot injection and would then take his antipsychotics orally in the community. Note that this was someone who had previously been reluctant to take his medication. And there were then mixed reports about his subsequent progress, but he went on, as I mentioned earlier, sadly, in February 2015, he stabbed his father and his daughter before he was shot by a police firearms unit, and was, of course, himself very badly injured because of the shooting. So both Mr. Traylor and his daughter subsequently sued the defendant trust that was responsible for his mental health care. On Mr. Traylor's behalf, it was argued that the negligent treatment of his mental illness had caused the events of February 2015. And the trust accepted that there had been a breach of duty in respect of a decision to discharge the claimant from secondary health care, but that decision had not made a difference to the outcome, as the claimant would have continued not to take his medication even if he had not been discharged. But the trust denied the other allegations of negligence. And Mr. Traylor's daughter brought a separate claim under the Human Rights Act 1998, and she argued that it had failed to take positive steps to protect her right to life and her right not to be subject to inhuman or degrading treatment, and that those failings resulted in the events of February. So Mr. Justice Johnson rejected the negligence claim and the Human Rights Act claim, but he went on to consider, and this is the more interesting bit of the decision, and reject the illegality defence that was relied upon by the defendant. So, as I said, the claims themselves unfortunately failed on factual grounds because breach of duty was not established. But what's helpful and interesting from the decision is to consider the court's decision in respect of the illegality point. So the trust had argued that the illegality of Mr. Traylor's actions provided it with a complete defence against his claim negligence. But the trial judge said this was not a defence that was available to the trust because Mr. Traylor had been found not guilty by reason of insanity. And he noted that he did not accept the submission that Mr. Traylor was to be treated as having committed a criminal act. And he went on to refer to numerous authorities which suggest that the illegality defence only applies where the claimant knew he was acting unlawfully. But interestingly, he did go on to find that if he had found for Mr. Traylor, he would have reduced his damages by 75% for his contributory negligence in failing to take his oral medication and lying about his failure to take his medication to those who were trying to assess him. In respect of the claim by Mr. Traylor's daughter, the court held that the defendant had fallen under a positive duty to provide protection against the risk posed by her father under Article 2 of the ECHR, following the well-known decision in the case of Osman in the UK. And this was triggered if the defendant knew or ought to have known that there was a real and immediate risk to her life or physical safety. But the submission that the defendant had failed to take reasonable steps to avert this risk was rejected for the same reasons given in respect to the father's claim, that an appropriate risk assessment had been undertaken, appropriate advice had been given, and continuation of the secondary treatment in the community would not have averted the events that happened. Okay. The next case I'm going to talk to you about is the case of Radia and Professor Marks. Again, this is a High Court decision from early this year. This was a claim against a single expert witness. And it raises an interesting point in respect of credibility and the responsibilities of expert witnesses when they are considering the credibility of a claimant. So this claimant sadly suffered from acute myeloid leukemia. He brought an unsuccessful claim alleging disability discrimination against his employer, which was then unsuccessfully appealed to the Employment Appeal Tribunal. The defendant in these proceedings, Professor Marks, had been instructed as a single joint haematology expert to give evidence on the effect of the claimant's condition following his return to work. So in the first instance, the Employment Tribunal found that in a number of respects, the claimant had not told the truth, that he'd intentionally misled them. And the Employment Tribunal claim comprehensively failed, and there was no appeal from that judgment. But in the costs proceedings that followed, the tribunal found that in his Employment Tribunal claim, the claimant had acted unreasonably by telling lies which were, and I quote, deliberate, serious and central to the case concerning his weight following chemotherapy and concerning a holiday in Mexico in May 2011, which he alleged that he had been forced to miss. It's a sort of nightmare scenario of a potentially exaggerating claimant that unfortunately we're all too familiar with in the work that we do sometimes. So the unreasonable conduct that was referred to justified an award of costs in respect of those complaints. But the tribunal also found that a whole costs order should be made because none of the many complaints of disability discrimination had had a reasonable prospect of success, and the claimant had acted unreasonably in commencing such a claim when he knew or ought to have known that the complaints were unmeritorious. So the claimant appealed that cost ruling unsuccessfully. His eventual cost liability in his ET proceedings was a shade over £600,000. But all of that brings us now eventually to the claimant's High Court claim against Professor Marks. So for all of you who are wondering how he fits into this, the claimant's case in the High Court was essentially that in breach of duty, in tort and in contract, the defendant, Professor Marks, misreported the claimant's account to him concerning his chemotherapy-related weight loss, and that he then compounded his error, again in breach of duty by not undertaking a competent review of the medical records, which would have revealed the error in the report, and taking steps to correct his mistake. And he went on to argue that the discrepancy between the weight on the as recorded by the defendant in his report and that recorded in the medical records was explored during the liability hearing, and this discrepancy was the root cause of the tribunal's conclusion that the claimant had been untruthful, which is what the claimant argued then led to his adverse liability findings and the adverse consequential costs order. So the defendant effectively was arguing that, the claimant was effectively arguing that the defendant owed him a duty of care, both tortious and as an implied contractual terms, to exercise all reasonable care and skill to be expected of an experienced, skilled and competent expert witness. And it was alleged that the claimant relied on the report, and in reliance of the defendant's oral evidence, the claimant continued to pursue proceedings in the employment tribunal. The defendant denied breach of duty, as you might expect, but also raised other important arguments. So crucially, the defendant argued that the harm that was being alleged here is the finding of dishonesty, and that any duty of care owed by the defendant did not extend to protect the claimant from such a risk, so the risk of a finding of dishonesty against him. And secondly, that the claim should fail on causation. So the tribunal had found that the claimant had been dishonest for many reasons, including his demeanour in court. And even in absence of the discrepancy between his weight when discharged from chemotherapy, the outcome would have been the same. The court concluded that while Professor Marks undoubtedly owed a duty of care to the claimant and to his employer in respect of the report that he provided and in respect of the evidence that he gave in the employment tribunal claim, that duty was not limitless in its scope. In particular, the issue is whether the scope of the defendant's duty to the claimant extended to protect the claimant from the risk of an adverse credibility finding or a finding of dishonesty. Without hesitation, my answer to that question is that it did not. So the court considered, for instance, the letter of instruction that had been sent to the expert and noted that it was no part of his retainer by either party to advise or assist on issues concerning the credibility of the claimant or the reliability of the claimant's evidence, nor was it part of his retainer to advise on the credibility of the employer's witnesses. That was not the purpose of his instruction. And crucially, nor could a medico-legal expert in these circumstances give evidence about the credibility of the claimant or any party. The expert's opinion is admissible only to the extent that it addresses issues which are within his or her expertise and not matters of common knowledge which the tribunal would be competent to address for themselves. Although a question was posed of Professor Marks by the counsel instructed by the employer, inviting him to agree with her that a person who is unreliable in one part of his evidence is likely to be unreliable in another, this question was impermissible. As well as inviting speculation, it was not within the defendant's expertise to comment on that point. I just want to pause there briefly. We know that in cases where the claimant's credibility is being questioned, usually by defendants, it is common practice to try and put questions either in writing or subsequently at trial to the expert that try and get the expert to comment on the claimant's credibility. And I think I would just advise caution on that front. And certainly, if you're for the claimant, I think it would be helpful, if appropriate, to be referring the defendant to this guidance from this particular decision and reminding them that from the court's perspective, it is not within an expert's expertise to comment simply on the question of credibility most of the time. But the court went on to note that the defendant was, so the expert was in no better position than the tribunal, or anyone else for that matter, to give an opinion on whether the claimant was telling the truth. Putting it succinctly, the scope of the defendant's duty of care in this case cannot extend to the protection of a party from a risk upon which the defendant was not competent to give an opinion. And the court accepted that one of the effects of a medico-legal expert's evidence may be to highlight an oddity or inconsistency or discrepancy in lay evidence, which may then go on to form a tribunal's judgment on matters of credibility and reliability of parties and witnesses, and that happens frequently. But the fact that this is or may be a side effect of the expert evidence does not extend the scope of the duty of such an expert to protect a party or witness from the risk of adverse credibility findings, just as it is no part of the role of the expert to seek to support the credibility of a witness to party. So a reminder there, it goes both ways, just as defendants should be cautious before simply relying on an expert to try and bolster arguments that a claimant is lacking credibility. Similarly, the court's advised caution when it comes to claimants who try and rely on the expert to try and bolster the credibility of their client. The critical duties and responsibilities of an expert, the court went on to note, consistent with the overriding objective, include objectivity and independence. So expert evidence should be and should be seen to be the independent product of the expert, uninfluenced by the exigencies of litigation. An expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within their expertise, and the court dismissed the claimant's claim. Again, it's just, there's a few sections of that decision which I think are just a really helpful reminder to all of us of what the scope and the role of an expert's duties are. So I would urge you, if you get a chance, to try and have a read through that. And finally, with 7 minutes to go, we come on to the final case of Polmear and Purchase, which is the Court of Appeal decision decided at the beginning of this year. Again, those of you who attended our seminars in March will recall an excellent talk given by James Bentley, which dealt in full with the impact of Polmear and Purchase. So in the interest of time, I'm going to go very quickly through the principles arising from this case. It's a trio of cases that considered the question of secondary victims for psychiatric claims in the context of clinical negligence cases. So essentially the question was, in which circumstances can a defendant in clinical claims be held liable for psychiatric injury caused to a close relative of the primary victim of that negligence? So in each of the cases involved, the defendant was alleged to have failed to diagnose the primary victim's life-threatening condition, and at some time after that negligent omission, the primary victim suffered a traumatic death. So in two of the cases, Paul and Polmear, the shocking death occurred in the presence of close relatives, causing them psychiatric injury, whereas in the case of Purchase, the close relative came upon the primary victim immediately after her death, again causing her, being the mother in that case, psychiatric injury. So the question in each case was whether the necessary legal proximity existed between the defendant and the close relative, who's often referred to as the secondary victim. So the court in this case reminded itself of what have become known over the years as the control mechanisms derived from the well-known earlier case of Alcock. Some also call them the 5 elements in Lord Oliver's test, which is what you require to establish proximity in secondary victim claims. So firstly, that in each case there was a marital or parental relationship between the plaintiff and the primary victim. Secondly, that the injury for which damages were claimed arose from the sudden and unexpected shock to the plaintiff's nervous system. Thirdly, that the plaintiff or claimant in each case was either personally present at the scene of the accident or was in the more or less immediate vicinity and witnessed the aftermath shortly afterwards. Fourthly, that the injury suffered arose from witnessing the death of, or extreme danger to, or injury or discomfort suffered by the primary victim. And lastly, that in each case there was not only an element of physical proximity to the event, but a close temporal connection between the event and the plaintiff's perception of it, combined with a close relationship of affection between the plaintiff and the primary victim. And in addition to legal proximity, Alcock found that reasonable foreseeability was necessary on the part of the defendant. In that combination of circumstances, there was a real risk of injury of the type sustained by the particular claimant as a result of his or her concern for the primary victim. So I'm not going to go through in detail the facts of all the cases because I'm conscious of time. So it's simpler and probably for your purposes more important if I tell you what the Court of Appeal concluded, which was in essence that it was bound by earlier Court of Appeal case law in respect of how to interpret the Alcock control mechanisms when looking at clinical negligence cases. So principally, the case that it considered itself bound by was the case of Crystal, Taylor and Novo. This is a 2013 Court of Appeal decision referred to simply as Novo. And in this particular case, so Polmear and Purchase, the court concluded that the 5 elements required to establish legal proximity in secondary victim cases apply as much to clinical negligence cases as they do to accident cases. And they went on to emphasise that the question of what is a horrific relevant event is not dependent either on the completion of the primary victim's cause of action for negligence or the first manifestation of injury to the primary victim. For a secondary victim to be sufficiently proximate to claim for psychiatric injury against the defendant whose clinical negligence caused the primary victim injury, the horrific event cannot be a separate event removed in time from the negligence. And if the negligence and the horrific event are part of a continuum, there is sufficient proximity. And Novo is binding authority for the proposition that no claim can be brought in respect of a psychiatric injury caused by a separate horrific event removed in time from the original negligence accident or a first horrific event. So that is the current position. And obviously, if you've got any secondary victim cases at the moment, you will want to look very carefully at the judgment in this case, which is not too long, but to get a better idea of how to approach that issue. But you should also know that not only has permission been given for an appeal to the Supreme Court, which is awaited, but also that the Master of the Rolls said the following when he was giving judgment in this case. He said, "I accept that, although there is no logical reason for these rules, they are the way Mr. Justice Auld in Somerset and the Court of Appeal in Novo built upon the 5 elements and adapted them to the clinical negligence context. If we were starting with a clean sheet, I can quite see why secondary victims in these cases ought to be seen to be sufficiently proximate to the defendants to be allowed to recover damages for their psychiatric injury. Since, however, this court is bound by Novo, it is for the Supreme Court to decide whether to depart from the law as stated by Lord Dyson in that case." So you've got the very obvious steer of the Court of Appeal as to what direction they would go in if they were able to, and we will have to wait and see what the Court of Appeal makes of that. So with that in mind, I appreciate it's been a bit of a whistle-stop tour through many different aspects of the developments in clinical negligence cases more recently, but I hope you found it useful. As I mentioned at the outset, if you've got any questions at all, then please feel free to email me either directly or go via my clerks. The slides from today will be sent round to you in the next day or two. and the recording from today's webinar for people who missed the beginning, for example, will also go up, or a link to that will go up on our website in due course as well. So thank you very much for listening to me, and I hope you have a very good rest of your day. Good afternoon.